Thank you, Your Honor. Please, court.
You may.
State. Afternoon, ladies and gentlemen. Let me first start off just by thanking you guys for the time and attention that I've seen you put forth during these last few days. I've watched you listen intently. I've watched you pay attention to things. And I want to thank you. I want to thank you because without citizens like you, this entire process doesn't work. And so I thank you on behalf of my client, Mr. Chemirmir, and for the entire system. So before I jump into what we want to describe as the meat of my argument, I want to take us back to last Wednesday when I spoke to each one of you during board diary and let you understand and explain to you why you are sitting here. You know, normally we say you're sitting in these comfy chairs, but because of the obvious you're not. You're sitting in these little harder chairs out here. But the reason that you 14 are sitting here is because last week you told me during the board diary process, which at the time all you told me, or all you were promised to do at that particular point, was to tell the truth. And by way of your answers and me believing that you told me the truth last week is the reason that you 14 are sitting here today. And based on what you told me last week, I'm going to ask you to do what you told me you could do and would do. And that's to follow the law. See, when we got started on Monday, prior to you hearing any kind of evidence or any kind of testimony in this case, you all stood up, you raised your hand, and you told us in this court that you would follow the law that is applicable in this case. And that's all I'm going to ask you to do. I'm not asking you to do anything outside of that. It's to simply follow the law. And in following the law, let's think about what that means for a jury. So as we discussed last week, yes, you're 14. But before you come 14, you have to be 1. So in looking at it and evaluating and making decisions regarding what you believe, how much weight to give, and that's all the information that's contained in this charge, and we spoke about it last week, but now you have it here in writing, is that each one of you, you're the one to make the decision regarding how much to believe and not believe. Yes, the evidence that's been submitted to you for your consideration comes from the witness stand, absolutely. But that's it, just the admission of it. When you hear, no matter who do we talk about last week? We talked about witness credibility and the things you're supposed to make a decision and determination on. Whether it's an expert, whether it's a layperson, whether it's a police officer, whoever it is, when that evidence comes in, you make the determination what weight and how much credibility to give. You don't have to accept any of it. Just because it's admitted, you make the determination of how you want to evaluate it and how you want to use it. That's for each one of you. And in the charge, it also talks about the presumption of innocence. Presume innocent, not until, but what? Unless. He's presumed innocent unless he's proven guilty. You hold on to that. You're charged with that. You've promised to adhere to that. And, you know, Mr. Barney said, you're going to hear a lot about beyond a reasonable doubt. Absolutely. And why shouldn't you? That's what this entire case is about, is reasonable doubt. And it is rampant. It's rampant throughout these proceedings. You see, here's the thing, ladies and gentlemen. The state has the burden of proof. They have to prove to each and every one of you, first individually, right? Individually, you have to make a determination of what you believe before you can even deliberate. You can't have a conversation with someone if you don't know what you believe, right? You have to decide. And then you make the decision. That's what it says. And you know, the misnomer in regards to jury duty is people think that a jury is, you're required to reach a verdict. That's not what you're required to do. What you're required to do is to listen to the evidence presented and deliberate. You're not forced into a verdict. You're not forced to agree. If you don't agree, that means you don't believe the statement is burden. beyond a reasonable doubt. And if you do not, and you believe that they have not, then you're allowed to stand on that. And each and every one of you owes each other that respect of listening to that. So, regarding beyond a reasonable doubt, you ever heard of the term quality over quantity? See, what the state has done for all these cases, you see, because I'm sure like you, or excuse me, like me, you all probably got confused on what case you were here for. Because they're bringing in all kinds of stuff, right? But ask yourself this, why? Because the case before you that you're just in charge of making a decision on guilt or innocence is not Ms. Brooks, it's not Ms. Bartell, but it's Ms. Harris. And so you're probably saying, why is all this coming in? And the state says, and they're going to say, well, circumstantially, and the relationships, and the motive, and lack of mistake, and all these other legal terms that it's in the charge, they look at it. But what you can't get caught up on is grouping all that together. Because see, the law allows you that you can, honestly, you can believe you wanted to that Mr. Chemirmir killed Ms. Brooks. But the state did not prove to you beyond all reasonable doubt that he killed Ms. Harris. That's what I don't want you to get caught up on. And that's exactly what the state wants you to get wrapped up in. You see, they've introduced almost 300 pieces of evidence, almost 30 witnesses, and 2 extraneous offenses for this one case. But Mr. Barney gets up here and says, it's real simple. Go back there, tell him real quick, we know what you did, convict him. If it was that simple, but they need all this quantity over quality? Because of all this evidence, and I'll use my air quotes, all this evidence the state brought you, right? What didn't they bring you? Because see, they're going to tell you all the things they did bring you. Some of the things that they want to bring to you, they want to argue is compelling. In regard, let's just talk about Ms. Harris. They brought you this money. Did they bring you any kind of bank document, withdrawal slip, a bank teller, anything that said she went to the bank and withdrew these $2 bills? Nope. Her son-in-law said that, yes, she would give us $2 bills and Christmas cards. 400 $2 bills. Quantity, not quality. Mr. Barney gets up here and they want to bring you invoices from Diamond Gold and Exchange from 2015 to 2018. Okay. We never hear from the fact that he sold jewelry. But they want to say, and he quotes this number from 2015. It's in evidence, 288. From 2015, he made $91,000 selling jewelry. So, what does that mean? Absolutely nothing. Absolutely nothing. What did the owner say, Mr. Nassad? He said, yeah, we've been open since 2008. I said, you have some people that come in and they'll sell one piece and you won't ever see them again, right? Yeah, it happens. I said, yeah, sometimes you have people that you've had that you've opened before, right? Yeah. Yeah, that happens. I've had them for years. This isn't abnormal. I said, that's good for business, right? Yes, sir. Mr. Fitzmartin said, it's a business model. Repeat business. Quantity, not quality. So let's talk about these extraneous offenses. Because they're super hung up on this Nissan Altima. What did I ask Sergeant Pagel? She's the supervising patrol officer for Plano. I said, well, Sergeant, you're in the patrol division, which, you're on the highways, traffic tickets, responding to things. That's an extremely common vehicle, isn't it? Yes, sir, Mr. Warren, it is. So March 31st, they have maybe it's Nissan Altima. You look at the camera, you make the decision. Maybe it is. But what don't they have again? They can't identify a driver. They cannot identify a license plate. They can't identify anyone in the vehicle. More importantly, no one even gets out of the vehicle on that day. But they want to use that, present that to you as evidence against Mr. Chemirmir. Think about the evidence they presented to you guys on regards to Mary Brooks. No direct evidence whatsoever. They talked about a relationship. How about a lack thereof? There's absolutely no connection whatsoever that they have here for you. None. No videos from Walmart. No videos from the apartment, the condo complex where she lives. No witnesses. That's kind of been a consistent theme with all these. And think about it. You have Mary Brooks, January 31st. You have Ms. Bartell, March 19th. And then you have Ms. Harris on March 20th. On all these days and times, not a single witness can place a vehicle or Mr. Chemirmir at their places of residence. Nobody. It's 2021 now, but even I submit to you in 2018, Ring doorbells, traffic cams, videos and cameras in apartment complexes, condos were rampant. Cell phones, everybody has something. Nosy neighbors, but nobody. Not a single person in any of these alleged offenses was able to identify this man. And you say, well, Mr. Warren, but you know, they brought in the FBI. They brought in Agent Sedgwick. And he showed us all this on this fancy map that they're going to put up. Mr. Fitzmartin's going to put it up. He's going to point to it, and they got their little pictures and everything. And they're going to say, hey, look at this. And you know what they're going to say? It's approximate. You know what the definition of approximate is? It's not actually, not exact. It's a guess. It could be. See the hot dog? He's somewhere in the hot dog. Or not even he. His device, if you believe that. Once again, you make the determination, you make the decision the way that you want to attach to it. Sure, he came in, he laid out his credentials, all these things. You make a determination if you believe that beyond a reasonable doubt. That's up to you. And you know, we're here for the 20th, March 20th, 2018. So they say, well, we know he was at Walmart. We absolutely do know he was at Walmart. We saw it. What didn't we see? What didn't we see? What did Detective Sayers tell you when I asked him? No. Absolutely no contact whatsoever on that day between Mr. Chemirmir and Mrs. Harris. None. On all those cameras. And I guarantee you, if they had it, they'd have had it blown up and on another poster board and everything. They'd have had it for you, but they don't have it. Also think about the fact that on video, Mr. Chemirmir left 2 whole minutes before Ms. Harris. But he's hunting. Oh, I guess he was hunting those dozen eggs he bought. And the Dawn soap. Then he left before her. He drove away before her. Almost another 2-3 minutes. But they say he's in that area, so that's enough. It's not enough. That's not beyond a reasonable doubt. That they allege that he was there in the area, so is that good enough? I listened to you. I spoke to you all last week. We had conversations on this. I know it's not enough for you all. Here's another interesting thing. In the report submitted by Agent Sedgwick, on all the other days, on January 31st, on March 19th, they have all the fancy the hot dogs. Remember we called it the hot dogs with the approximation of the distance? Why not on March 20th for the case we're here for? Does that not seem odd to you all? On the day that's most important, because that's why we're here. Don't get lost in the mud. We're here on the 20th. That's why we're here. That's what they've alleged, and that's what they have to prove beyond all reasonable doubt. But like I tell you, for them it's quantity, not quality. And even speaking of the phones, we have evidence from their own witness that he had his phone. He didn't even have his phone the weekend of March 17th, 18th, and 19th. He didn't have it.
Objection, Your Honor. That is a misstatement of the facts. That witness said he didn't have it for that morning when he picked him up from the hospital, but he returned it to him later that day, on the 17th. That's a misstatement of the facts. I ask the jury to disregard that.
Ladies and gentlemen, the argument of the lawyers is not testimony. It is simply argument by the lawyers. You will recall all the evidence and testimony that you heard from the witness stand.
You recall the way you remember. You heard Mr. O'Ding. You heard him. Then they brought in retired Detective Saber. Good detective, known him a very long time. When I asked her those questions about the room, he said, I wanted him to say the first 48 room. That's the room, that's the famous room from the TV show. And I asked him, I said, well Detective Tabor, what are those tactics you use when you speak to someone? And he goes, yeah, well, we have tactics. Or that's what Mr. Fitzmartin described as tactics. But really, they're lies. And think back. When he spoke to the Plano detectives, they lied to him too. But they couldn't catch him in a lie, could they? The detective kept saying, well, it was on the 17th. It was on the 17th regarding the enterprise. Mr. Chemirmir was very consistent and steadfast. No, it was the 19th. And they had to concede. The state had to concede that it was actually the 19th when he rented the car. But going back to Detective Tabor, all those tactics that he used, and you watched it, you saw it, you heard it. Try to befriend him, try to get personable, try to get some rapport, a relationship. Hey, Billy, you believe in God? Think you're a good person? Yeah. Yeah, I do. I am. Yeah. Of all those tricks, of all those lies, of all those tactics that he used, what I asked him, I said he was extremely consistent in denying that he had killed anyone. Mr. Barney says, well, he didn't ask him, who or anything or what. When you don't kill anyone, you don't have to ask who, because it doesn't matter. I didn't kill anyone, and he was consistent on that. And so you say, well, Mr. Warren, but what about the stuff? What about the stuff he had when he got arrested? The beauty of that is, we don't have to prove when, where, or how he got that stuff at all. They have to. They've alleged it. They've charged it. So they have to prove it beyond all reasonable doubt. We're not charged with that task. We don't have to respond to that. So whatever you can think that he, because regarding the white truck and the Hispanic fellow that he got it from, that's what he told detective. You remember? Did they bring anything to the contrary of that? Those items that are contained in the jury box. He said, I bought the jury box as a whole. Took out what I wanted, threw the rest away. But we don't have to prove that to you. It's not our burden. It is absolutely not our burden. In any case, no matter what it is, you start with whether you're a prosecutor or a defense. Can you place the defendant at the scene of the crime? Because you can't place them there, then you have what? You have the wrong person. And what is consistent regarding these cases? Ms. Brooks, Ms. Bartell, and Ms. Harris. They can't place him there. You know what? They can't place anyone there. Going back to Ms. Brooks, you have a seasoned officer, Sergeant Harris, or acting Sergeant Harris, then I guess the weekend, told you, and you saw it. He said, for peace of mind, let me double check her just to make sure I don't see anything. So you saw it, checked her neck, checked her back, checked her abdomen. No evidence of being apparent injury. Calls it in, hey, we're good. Natural cause. And so, with Dr. Bernard, he says, well, initially that was the case. And I asked him, I said, so what was different between that initial assessment and when you changed your, because that's what he did. He changed his, or their, however you want to describe it. When I say their, Dallas Medical Examiner's Office, when they changed their findings. And it's the same thing I asked the doctor the other day. I said, well, can the situation change your medical findings? He said, well, no. How will we take that into consideration? See, nothing changed in regards to how they found Ms. Brooks or any injury or lack thereof on that day. But it fit their little formula. That's what it is. They have a little formula. And it just so happens that they believe that Mr. Chemirmir fits into it also. So they start here and they work backwards. And one of the things, and here's another interesting fact for you guys to ponder. So he said, well, one of the things is when they started, we received a phone call after the fact, after already ruled natural death, after already being released to the funeral home, after all these things, we received a call about some things were missing from her daughter. Her daughter called, said some things were missing. What was missing? There was a safe missing. It was once screwed in the closet. Okay, so it was bolted in the closet. Yeah. It's also about this rubber band, the technical security she had on that, where the printer and the safe was, right? Of all these, probably 220, 30 photos, do we see a single photo of that open closet where a safe allegedly was?
You have 7 minutes.
Thank you, Your Honor. Does that make sense to you? Don't you think that would have helped you in reaching a certain conclusion of maybe getting beyond having a reasonable doubt? So ask yourself, why? Why didn't they take a picture of the shelf? She said it was a spoon, a broken or bent spoon, and it had been pried up and away. Can't find it. Also, according to their theory, that Mr. Varney said that he sees dollar signs. You saw the photos. You can look at the photos again from Ms. Brooks. There was a lot of jewelry that could have been taken. And the amount of time they alleged that someone would have had to be in there, why wouldn't they have taken all those? A whole big jewelry stand on the left side, and then on the right side was where she keeps her everyday jewelry. It's their theory. This is what they have to prove beyond a reasonable doubt. A baseball analogy is tie goes to the runner. In a court of law, when we're dealing with a criminal offense, tie goes to Mr. Chemirmir. You don't give the benefit of the doubt to the state of Texas. You don't give them Well, they got close. We talked about this. We talked about this for almost my entire time at voir dire. It's about beyond a reasonable doubt and being able to hold the state to its burden. You don't get to help them. And I told each and every one of you, it was a hard scenario. A lot of people struggled with it. If they only proved 5 or 6 or whatever it is the elements are, would you be able to do it? Might hurt, might sting a bit, but would you be able to do it? Each one of you told me, and that's why you're sitting here, that you'd be able to follow the law. It's another thing we spoke about. The difference between what? Innocence and not guilty. You might be sitting there thinking, well, Mr. Warren, he's not innocent. Maybe he is, maybe he's not. None of us were there. Because see, Mr. Varney said, forget reasonable doubt, it's beyond all doubt. Well, we all know that's a lie. It's not possible. Because in order for it to be beyond all doubt, it would have to be what? You'd be a witness, right? So it's not all. So that's just silly. Innocence or it's not guilty. Because see, the difference is what? We talked about it in voir dire. Innocence means the person didn't do anything. Not guilty means that they can't meet their burden, they can prove it. And that's where we are. That's where we are. The same way Mr. Varney stood up here and said, I want you to go back there and come back with a quick verdict. I'm okay with that. But the verdict would need to be not guilty. Because I submit to you without a doubt, I don't have a doubt in regards to them not meeting their burden beyond all reasonable doubt. And as each one of you go back there, because, and I say each one, because each one of you has to make your own determination first. You have to decide. You have to look at each and every bit of evidence. You have to make a determination of which witnesses you're going to raise their credibility or lower their credibility, or which evidence, how much weight you're going to give particular evidence, and making a determination of whether or not they met their burden. And once you do, once individually you do, then you deliberate. And I'm not telling you not to listen, I'm not telling you not to participate. But I'm also telling you that you have the power and the right not to change your mind. And your other members of the jury need to respect you. And the same, you respect them. Ladies and gentlemen, over these last few days, like I said, you've listened to a lot of testimony. You've seen an exorbitant amount of evidence and items put in. But we're talking about quality and not quantity. And I'm going to end my argument the same way that I ended my voir dire. Of reminding you the same way last Wednesday, before I sat down, I asked each one of you, I said, and I looked at each of you now like I'm doing now, and I said, if you were an individual sitting in that chair over there, would you want you as a juror? And I said, I want you to think about that. And what that means. Would you be able to be fair and impartial and actually listen to the evidence? Not what the popular opinion may be. Not with wanting to feel like a good citizen and doing what the state of Texas requests you to be. But actually doing what's right and what you've promised to do, which is follow the law. And each one of you, the reason you're sitting here is because you told me that you would want you as a juror. And that's what you would be able to do. And I'm not asking any more or less of you than that. Thank you for your time and your attention. And we look forward to you deliberating. And we look even further towards you acquitting Mr. Chemirmir. Thank you.